Welcome to another episode of the Cincy Law Cast, where we bring you insights and conversations from the University of Cincinnati College of Law community. Today we're going to be kicking off an exciting three-part series, the Law Review Takeover. In this special series, we're going to be sitting down with members of the University of Cincinnati Law Review to dive deep into what the Law Review is all about. So sit back, relax, and enjoy the first episode.
My name is Megan Bowling, and I am the outgoing editor-in-chief of Volume 92 of the University of Cincinnati Law Review. After the bar, I will be going into corporate and transactional legal work here in Cincinnati.
My name is Griff Bloodworth. I was the managing editor on Volume 92 of the Law Review. Just finished up with that last month ago or so. And then after I take the bar, I will be clerking for a judge, an Ohio State appellate judge, and then hoping to go into public interest law or criminal defense.
My name is James Hardman, and I am the outgoing business manager and outreach director for Volume 92 of the University of Cincinnati Law Review. Once I take the bar, I shall be also working in corporate law here in Cincinnati.
My name is Cecilia Giles. I'm the incoming managing editor for Volume 93, and I still have a year of law school left, so we'll see how that ends up in a year.
Start this off by giving a base level of some of the terminology that is involved with law review. We have blogs, we have notes, and we have comments. What does that mean in the perspective of law review versus maybe what the traditional vernacular might have a definition for that word?
Yeah, sure. I can go ahead and get us started off on that. So basically at the Law Review, we have two what we call tracks. The tracks are basically like the kind of content you'll be writing as a student. So when you come in, you're assigned to either blog, traditional, or hybrid. If you are on the blog track, you're writing blogs. And those blogs are going to be around 8 pages of content of a legal piece. So you have your legal thesis, and then you have your research and all of that. So that's what a blog is. And then we have on our traditional track, the two subtypes are the note and the comment. So traditional track pieces are around 25 pages long, double space, so you don't have to freak out too much. So those are double space, and you write that over the course of the entire semester. And the notes for those notes are commonly what you might think of as like a note is something that is detailing a circuit split. So some sort of like judicial disagreement. A comment, and sometimes the difference can get a little ambiguous. A comment is going to be something, the way I think about it is kind of you're going into more of a policy argument, or you're going into an area of the law that could also be like regarding like this law should change for this reason. Whereas a note might be more of a, you're kind of looking at the way that two different court systems kind of review things. Do you guys have any other thoughts?
Yeah, I mean, I think the easiest way to break between a note and a comment is basically if the bulk of your article is talking about one or two judicial decisions, usually recent ones, then it's probably a case note or a note.
Probably a note,
So it's talking about a particular case or set of cases, whereas a comment's like on a more general topic, right? So if there's not one or two, or maybe 3 in a rare case, but like not a couple of specific decisions that are at the heart of your article, then you're probably writing a comment on a more general area of law. And often it does go into that policy type stuff. And it's worth noting that like what we're talking about here is the stuff that students contribute, right? So like they're taking a step for even further back, there's 2 divisions to the law review in each published version. There's a front half that's what we call lead articles. So they're going to be written by academics, professors, practitioners, legal professionals. And we edit and publish those in each issue. And then the back half of each issue is going to be student notes and comments, these traditional track publications. And then in addition to that, we have an ongoing blog that supplements that with a lot more of like the hot topics in the news is often what's going on, or like little decisions here and there that might go unnoticed that somebody wants to meditate on or analyze. And so that sort of gets in the ripped from the headlines a little bit area more than the traditional track stuff, which is going to take longer. So it would be ripped from like 6 months ago's headlines. So
Yeah.
it doesn't work as well.
I think another important distinction between case notes and comments versus our blog is kind of how I think about it is who the audience is. So case notes and comments are usually written for people in the area, in the field of law. So somebody like a practitioner, an academic who knows, who has a more in-depth understanding. Whereas blogs, I kind of like, they're more for people who might not be as familiar with an area. So I kind of, when I was writing both of those, I kind of kept those audiences in mind. And
Definitely.
Yeah.
Yeah. And I think too, like, oftentimes various practitioners and other audiences or other law students, they're looking at notes and comments for their own research, when they're looking for
Definitely.
secondary sources. And they'll look at blogs as well, but traditionally they're looking at notes and comments for those when they're creating their own research. The other thing too that I'll just throw in is that for the blog, I mentioned that, so I mentioned for traditional track, you either write one note or one comment per semester. For the blog, you're writing so for the blog, you're writing 3 blogs per semester. So you're writing on various topics there.
But they end up being about the same length in terms of a total amount of writing.
Yep.
I suppose the other difference as well between the two is that, or at least between notes and comments on one hand and blogs on the other, is that with notes and comments, as you said, Megan, they are more involved when it comes to the research, and people might use them in their future research. And as a result of that, there is more a higher requirement for the for checking to make sure no one else has previously written on that exact
That's a
topic.
great point. Yeah.
Whereas
Preemption.
for preemption checking, exactly. Whereas for blogs, it's more, as you said, ripped from the headlines. It's taking a current issue and writing about it now. And in a way, it's less important if someone else has written about it on that exact topic, at least, as long as it's not exactly the same thing,
Right.
of course.
Right.
So when you look at the process of you first coming in, you're learning about these tracks, you're learning about what all this means. I know that there's an initial training and process, but how do you mainly figure out which track your skills might be more suited for, or is it more of testing the waters in both and seeing? Because we'll hear more about in the later podcasts an example of a longer form one that was used in court and other aspects, and then blogs that were used for allowing students to put their thoughts and their questions out about a topic so that people can kind of engage in a conversation. But how do you maybe, a potential student, how do they figure out which track they might be best for? Or is there anything they can be doing now to kind of better understand those different types of writing styles?
I think it's a really good question. So one thing to clarify is that if you choose to do traditional track, you don't have to say, oh, I'm going to do a note, I'm going to do a comment. You just say, I'm doing traditional track.
And I think it's probably worth noting that we talk about notes and comments like they are in discrete boxes.
Yeah.
The reality is that most people don't actually think about whether they're writing a note or a comment
Totally.
when they're writing it. We use those monikers later on to sort of tag them on, but like the reality is you write about a topic you're interested in, you do thorough research, and you present an argument. And if it's a narrow one, that's about a couple cases, we'll call it a note later on.
Yeah.
But the line is
Very
pretty blurry.
That's a super good point.
So
Yeah.
you're saying basically when you come in, you get the freedom to write the piece in the way that best represents the way you feel the piece needs to be written, and then you give a distinction to it after the fact.
Yeah, and I think that one of the useful things about the terms is that they help you sort of shape how you're thinking about the piece. If you're trying to figure out how to shape it, they can be useful to you, but they're not prescriptive necessarily. They're a good starting point to think about, is this the kind of mold that I want to cast my argument in? And if it is, then great. You can use sort of the traditional note structure of, this court decided A, this other court decided B. A and B are not equal. Therefore, let's discuss which is the better analysis, which is perfectly awesome if that's the thing you want to write about. And if it's not, then you write about it the way that you think is most appropriate. Mine was called a note, I think, right?
Yeah.
I think technically mine fell into the category of note when it came down to voting or whatever. but mine was not like that at all.
Yeah.
And you probably could have put it as a comment if you squinted hard enough, because I was writing about three recent decisions from the Supreme Court, and sort of how they related to one another and the inherent issues and tension there. So like, I wasn't sure that it was going to be
Totally.
And there's a far greater distinction between those and comments and blogs, and making that choice is more consequential in a way.
Absolutely. I had a really hard time deciding if I wanted to go for traditional, blog, or hybrid, because I was like, I've never done this before. I don't know what I will like.
And hybrid track is where you do one semester on traditional and one semester on blog.
Exactly.
Which is what I did.
Yeah.
Me too.
And so I thought that I knew that I had done long form writing before and that I enjoyed it. So my number one pick was traditional. My number two was hybrid, because I thought, that would be cool too, to do something where you get to write about different topics. But I personally thought I might get overwhelmed trying to decide 3 different topics over the course of a blog semester, just like trying to find something else to write about. And the scheduling is just a little bit different. And I thought, okay, if I do traditional, I can kind of plan it all out for the semester instead, because that's just kind of how my brain works. And so I did traditional and I loved it. I do think I would have really enjoyed doing hybrid and having the chance to do blog too. So yeah, that was kind of my process. And I talked to other students. I was like, hey, Paul, you did traditional last year. Like, what did you like about it? What did you not like about it? I like Bailey, you did hybrid. Like, what did you like about it? What did you not like about it? And just kind of hearing people's thoughts from their experiences. And that was super helpful for me. So curious to hear your guys' thoughts.
I would say another consideration is whether you want to be published, whether that's important to you. Because on the traditional track, or if you're writing a traditional article in that particular semester, there are only so many articles that can physically be published within the Law Review. Whereas with the blog, it's online, and I believe that most, if not all, of the blogs are published. And so it's a way of getting your writing out there. It's something you can put on your resume. It's something that is also, for blog writing at least, it's good practice potentially for the future as well, since a large number of legal firms, law firms, get their junior associates to contribute to blog type articles. So it's a good way of getting some practice in ahead of time.
So when we're talking about your all's writing and the publications and all of that stuff, I think we all have a pretty traditional idea of what a published article looks like when it comes to just everyday life. What does a law review published piece of work look like, differing from like a newspaper article or one that someone may traditionally feel that they've read more often? Or what skills that, let's say, a journalist student who's an undergrad and wants to come to law school, are those the same skills you need to write an article like this, or are there different skills that change what it means when you're writing a piece in a law review or a legal aspect versus mainly a traditional newspaper or just news content about a legal issue?
Honestly, blog it has some similarities to a newspaper article.
Yeah.
In the sense that the blog articles are often about current events. They are going to be quicker. They're going to be briefing an audience on a topic pretty quickly, getting them up to speed and looking at some factual stuff from day to day. Like published articles, the traditional track articles, notes, comments, whatever you want to call them, are going to look a lot more like something in between what you would think in a humanities secondary peer-reviewed published journal, right? Like you probably read in undergrad or what have you, the ones you had to look up for research papers on JSTOR or EBSCO or whatever. And so it's going to look a lot more like a hybrid between that and a research paper, because there's a little more structure, and they're usually a little more heavily footnoted. Law review articles are than humanities articles, at least in my experience, because frankly, lawyers are have an internal boiling terror of saying an unsupported statement. It is a deep-seated everyone else has terrifying dreams of showing up in their underwear, and a lawyer has terrifying dreams that they missed a footnote on the end of a sentence.
And law students.
And law students.
But it's also, that goes to the fundamentals of the common law in a way.
Yeah. Yeah, like that's what, I mean. That's how we do law in this country in the
Yeah,
Anglo-American tradition, right? It's building case on case on case. So a judge decided one thing, and then you've got a case that's very similar to that case. It should be decided the same way, and if it's slightly different, then you figure out how to differentiate.
Yep.
So you're always looking backwards at like the cases that came before to establish the law. So in that sense, yeah, the crisis in the terror and crisis and authority issue comes from that basic idea, but you wind up footnoting like the end of every sentence. It can be a little bit comical at times.
One thing that might be helpful for listeners to understand is like kind of the four components of pieces, both blog and case notes and comments. So we start out with an introduction, which introduces your argument, what you're going to be talking about, and then we move into the background, where you explain all of your sources, all of the background, the opinions, the legislation that support your argument, and then the third component is the discussion, where that's your main argument. That's where you're making your point. You're using what you described in the background to support your argument, and you're really kind of driving your point home. And then a conclusion is you conclude and restate it.
Yeah. And I think too, one of the things, if there's any current students or potential students who are listening, or anybody who's kind of thinking about joining Law Review, there are lots and lots of templates and lots of these pieces out there to be able to look at, to know how to structure your own piece. So it might sound daunting, it might sound detailed, but you are guided the whole way. And you know, it's not anything to worry about, I would say. I remember doing the write-on before my 2L year, and I was like, oh my gosh, am I doing this right? You know, like I'm looking at the 25-page paper, like that it was like a model, and I was like, I don't even know if I'm even close. And it's like, it's fairly formulaic, you know, like you have, like you said, Cece, like the four components. So I was like, okay, if I follow that, like we're good, you know, and that's true, you know, and it's one of those things, like anything else, the more you do it, the better you get at it. And so that's one of the great things about writing these pieces, is that it allows you to organize your writing well, and allows you to separate these areas out so you can really dive in and write a really well constructed, detailed piece.
I would say, before we move on to the next topic, that the other big differentiation between, say, a journalistic piece or some other type of academic writing and the type of writing we're doing in law review is the use of blue book citations, which is a particular style of citation writing which law students really, really love.
Well, I get law students at Harvard and Columbia really love it, but that's because they write.
That's because they
right.
Absolutely. So it's a skill set that you need to learn, but that law review helps you learn. And It's a skill set that really comes in handy if you're going into a field, because you use the same citation format, more or less here and there, depending on the court. If you go to work, it's throughout your entire career, exactly. If you're going to go work in either as a litigator, or if you're going to work for a judge, then those are the types of citation skills. Even if you're not going to follow it exactly, at least those skills, developing those skills early on in law school is a real leg up on future work.
So if we want to go into what does blue book citation mean for, you know, I'm sure people who are listening to this know, like, you know, your AMA and all of that type of what they think when they hear the word citation. But what do you mean when you say, you know, Harvard and Columbia write this blue book standard? What does that mean?
Well, it's a book.
Yeah.
And it's blue.
And it's blue.
Yeah.
Blue pages and white pages.
And you have it with you at all times, unless you have an online subscription, and then you have it bookmarked at all times.
But I'd say this goes to the fact that law review and law reviews in general are run by students. And so the citation format that we use is also managed by students. And there's a blue book committee or some such there's a group at least at Harvard and Columbia, and I think isn't it UPenn or something?
You know, I could try to say this and then I'll get sued for defaming Penn or something.
Regardless, it is run by students and created by students, and yet this is the format, the underlying format, which is used in American legal jurisprudence.
Did it start that way though? Was it actually? I don't know if it was actually created by students. It's just now updated and maintained by students. Was it originally created by students?
I thought, but I could be making that up entirely.
But regardless, that goes to that, and it's a very peculiar, very particular way of approaching citations and how to use particular cases or use formal journal articles or whatever it may be. There is sometimes a rule for it. If there isn't a rule, you have to try and make it fit as best as you can. But it's a skill to learn, because it can be tricky. It can sometimes be a little hard to know exactly what you're doing, but the more you practice, the better you get at it. And
Law Review will make you practice.
Law Review will make you practice. And in fact, one of the roles you can take on as in Law Review, at least here in Cincinnati Law Review, in your second year, is you can work focusing on citations and on making sure that those citations are correct, both in the lead articles and in the student articles as well.
So the history of the Blue Book is not entirely ascertained and known, but it was either started at Harvard or at Yale. And today it's compiled by the Harvard Law Review Association, the Columbia Law Review, the Yale Law Journal, and the University of Pennsylvania Law Review.
And I think I think it's competing between Erwin Griswold and Carl Llewellyn as to who wrote the first draft. So it wasn't the students initially. It was one of the greats of early 20th century Northeastern legal education.
Right.
Dependent.
But they came from the educational sphere.
Yeah, I would say as well, some law schools, they, as part of their write-on competition, which is something we can discuss in a bit, this is how you would get to join the law review. Some law reviews actually have a test specifically on your knowledge of the Blue Book. We don't do that, or at least we didn't do that, Megan, for our one. I don't know if Madeline is planning, and the new Zach are planning on doing that.
Just like you guys did, where you Blue Book your citations for your write-on piece are in the Blue Book form, and that's a component of how we grade the piece.
But we don't have a separate test specifically for it, which is partly because, at least in my view, which I think is shared, is that you will learn these skills when you are on law review.
Yeah.
You don't. There's not much point in needing to know it beforehand, because that's just an extra thing you would have to learn after already taking your first year finals.
Yeah.
So it would be
like familiarity is great, but it's not. It's not like the core. You know, like it's a very important part of the writing that as an associate member here at UC that you'll do, but you learn it as you go, and there's lots of resources and lots of help to help you along the way.
Precisely.
But what's the point of being in law review? What is the benefit for a student besides just the skill of being able to say you write better or you know how to do citations correctly? But like we've kind of heard, is that may not be a big part of what you do when you join a law firm, depending on what your focus is. Mm-hmm. So besides kind of understanding, it helps you understand the basics of law, but what benefit do you get? Where do these papers go? Do they just live in here until someone wants to look at them? What types of things can your papers be used for that then turn around and benefit you?
Well, the primary benefit comes from James, and it's that the office has snacks.
Exactly.
That's pretty much.
Oh, man. I could talk about this all day. I really love this topic, so I'll just mention a couple things, and I would really love to hear your guys' thoughts too. I think that being on Law Review, I'll just kind of start with some of the personal benefits. I think that Law Review allows you to improve your writing skills, which is a critical aspect of the legal profession, no matter what you go into. If you're doing in-house counsel, no matter if you're doing litigation, if you're doing transactional work, it runs the gamut. So it allows you to really strengthen your writing. It also allows you to write about things that you want to write about, which is awesome. And you don't always have that opportunity in a class.
I mean, one of the big things that I think not enough people take advantage of is it is sort of an excuse to delve really, really deeply into something that could be useful to you. And I don't know that I feel like some people don't take full advantage of that fact, and I wish they would. Like So my second semester traditional track article was one, it was on a very strange topic, but it was adjacent to a number of very interesting areas. And it wound up, it was about a bunch of procedural barriers to seeking DNA tests, a whole complicated thing. Point is, there are a bunch of these procedural issues that I knew very little about when I started writing it. And in my work as a clerk since then, like clerking for a firm, and in my work with the Sixth Circuit Clinic, actually, a lot of the issues that I researched about procedural due process claims, about like weird procedural nightmares, were directly relevant, and I had like been immersed in them for so long, like these technical real world things, that I felt very, very comfortable with them. And it's an opportunity to do that about what you are interested in working with.
The other thing that Law Review allows you to do, it allows you to actually, you can make an impact. So you ask the question of, what happens with these pieces when you're done, So if you are doing, I'll just give the traditional track perspective first. If you write a traditional track piece, then out of, let's say, 18 to 20 papers that are done that semester, 10 of them are chosen for publication here at UC, and then those are going to be published in subsequent printed issues of the Law Review. If you aren't chosen for publication, you can pursue publication elsewhere, maybe with another journal here at UC, or an external subject matter journal, or just something like that. But if your piece is published, then it's going to be published with the Cincinnati Law Review online, and then also in our printed volumes. And then there, people around the world can find these and use them for research, use them to cite them. We've had several people's pieces that have been cited in the last several years by courts that have been cited and looked at internationally, put into various reference lists, cited in other law review articles by students and by practitioners around the country and around the world. And so it really has the opportunity to go on and make an impact in all of these different spheres. The same is true for blogs. Blogs are going to be out online. They're not going to be printed in an issue, but they're online and people can find them. They can use them for research. They can use them to cite them in other law review pieces. And that has happened with our blogs as well. They can also, journalists might find them and find something that they're interested about. So people see those and just use them in all kinds of different ways. And that's one of my favorite things about Law Review. It's an opportunity not just to do these things that, help you in your future career as a law student and then as a practitioner, but it actually allows you to have an impact in a real way as a student, which is really incredible and humbling, and just like that, it's just awesome. And then those things live on for years. So your piece might not be cited for like 10 or 15 years after you graduate, but that's possible. And that happened just 2 years ago with one of our alumni, Jesse Janicki-Goldschalk. His piece was cited at the federal level just about a year and a half ago. And he graduated, I want to say, around 10, 15 years ago from law school. So that's, years later. And here it is now making an impact in the courts.
The benefit of reading a blog post about an issue versus reading the popular media coverage of that issue?
It's a middle ground between the academic and the sort of popular media type thing. So, because it's not going to be a dissertation with a comprehensive list of all the major writers on the topic. That would be a traditional track article, and those are for nerds. So I wrote traditional track articles, to be clear. The blog posts, I think, one of the nice things is that even though many of them may be from maybe arguing for a particular perspective, right? Like there should or should not be cameras, they will be coming at it from a more academically rigorous point of view where like you can't just say because they should or because it's good. That's not really the point of a blog post generally. Instead, at least a law review blog post, you can do what you want on your own blogs, but they're going to come at it from this is what the law is, and this is why my view works with or doesn't work with or builds on or requires a change in the law. And so you are getting, in that sense, it's going to be building upon a more objective basis, perhaps. But the views, there are going to be views of the author, and they're going to be one way or another, because just writing because it's a blog post and not a treatise section. Treatise sections are very dull and they are very informative, but they're not exactly an argument.
I think it really depends on the blog topic and the author as well. Like, I wrote 3 blogs, so I did the hybrid track. I wrote traditional, and then I wrote 3 blogs. And one of my blogs was about the recent Supreme Court case about access to the abortion drug mifepristone. And obviously that one I had some strong feelings about, and those definitely showed through in the argument that I made in my blog. But then another one of my blogs, I wrote about the impact of like kind of a copyright law standpoint of Taylor Swift's re-recording project on record labels. And obviously that one was not as opinionated. It was kind of just like, this is what's going on and this is what's happening. So there's definitely 2 really different standpoints that you can take from the blog perspective.
Yeah, I think regardless, you're going to see an interpretation.
Yeah,
An interpretation
definitely
will be present. But the perspective of the writer may or may not come out as much depending on the topic.
Yes.
Yeah, and I think you guys both really described that well, where it's like this. I think it is. The law review blogs can be great for someone who wants to go learn about a certain topic, and maybe they're like, I've heard all these different like anecdotes, all these different thoughts, and I want to get more of like a, this like kind of a little bit more solid ground about like this particular law or this thing that I've seen. It can definitely be a good place for that. Just because of the nature of it, because you're going to see the legal reasoning for why this thing is. And then you'll see, you could just read the background section to get that if you want. And then, you don't even have to read the piece's discussion, because that might go into, their thesis and their thoughts on something else. But the law will be present in that blog. And so it's definitely helpful for getting that context.
Okay. For all of those who are listening who maybe are now more interested in law review or the process of getting into law review, from your each individual perspective, what was that journey like from the write-on process to maybe picking which route you wanted to go? We've gone a little bit into that, but then also that next step. Now you have a position within the law review that's more than just an associate. What was that individual process like for all of you?
So for me, coming into the write-on, I was really nervous. I had like no context really for, what it would be like, other than just my, the students who had gone before me. But I think that that's really normal. It's like, again, it's like law school. I came in and I was like, I have no idea what to expect. I don't have any attorneys in my family. Like, we're doing it. So really, I think that the biggest piece of advice for going into the write-on competition is just like to like, just kind of take it step by step and know that like perfection is not at all expected. The writers know that you are doing this for the first time. The goal is to follow the prompt, to follow the instructions, and just be able to create a concise thesis based on what is given to you, and just being able to put together a good short piece of writing. That's really that's the main goal.
Can I just build off that? I mean, I think that all law review write-on submissions are varying shades of crap. Because it's a limited, which is fine.
Yeah,
that's the thing. Like, it should be a liberating reality,
yeah.
because it's a very short time span to write about an issue you probably don't know anything about, based on a weird set of sources that you didn't pick. And you're supposed to just create an idea. So that's the first thing to think about. But the other thing to think about is like the real thing to do. The main thing you need to do is just argue something, and you don't have to be right. Again, they're all varying shades of crap. So like, you just need to argue a point that is supported by the sources you use. You don't need to get it right, because A, there's probably not a right, and B, even if there were, nobody really expects you to get it. It just can't be altogether wrong.
Yeah. I would say as well that having now done the traditional track and then worked with the law review and seen the amazing work that the exec board, like Megan and Griff and everyone else put into the work, is that the write-on is not supposed to be the same quality as the articles you produce.
Absolutely.
It's like you guys have said, you go in and you follow the prompts and you put together an argument and you make that argument cogent, and you do the normal law school thing of you have your rules, your conclusion, your rule, your application, your comment. You kind of put it together like that in that paradigm, and you hopefully get something decent enough at the end that shows the potential for you to be able to write for law review. But that is just showing that potential. It's not, this is what your potential, this is what you are, this is the quality you're capable of. It's showing that, because that will come later. And that's certainly what I found.
It's showing you know how to handle the raw materials,
Yeah.
right?
Yeah,
like
exactly.
not showing like what your published piece will be. It's just showing you can handle the raw materials and that you can do something with them.
Yeah.
It doesn't have to be, the Mona Lisa.
Mm-hmm.
Yeah.
And I would just offer to people who are thinking about writing on, just remember that, as just echoing what you all are saying, write-on is so different than actually being in law review. Write-on, it's a necessary evil because we have to grade everybody on the same objective, on the same prompt. But so you don't get to pick the prompt, you have to write about it. I did not like my write on prompt, but I got through it.
You're welcome.
Sorry, Griff. It was Griff's topic. I didn't like my write on prompt, but then you get on Law Review and you get to write about something that you want to write about. And you have this support from your editors, from your exec board, from professors in the law school. So just remember that write on is not Law Review. It's just a hurdle that you have to jump over, and I would just do it. Just write it and see what happens.
So my journey with Law Review really started with just like looking at the write on and saying, okay, like we're going to do this thing. Like, I think I would enjoy Law Review. I know I like to write. I know this is a really critical skill. And so let's do it. So I did it. And then I decided, just kind of based on my own personality and like knowing like what I thought I might want to do, that I want to do traditional track. And I'm really, happy with that decision. I probably would have loved hybrid as well, but I did traditional track, picked my topic for the fall, went through that whole process, then did it again for the spring, which was, it's funny. The spring was so much easier just because, you've done this kind of writing before. So it felt like, it was really cool to be able to feel that confidence, your second semester. And then when, so as a 2L, you're doing all this writing, and some site checking in there as well. And then you have to start thinking about your 3L year, and you have to think about just kind of the kind of role that you'd want to take, because when you're a 3L, you are in some sort of editorial or leadership role. And so you get to kind of start thinking about that. So I started thinking about just what the direction I might want to go in, and just kind of the different sort of aspects that were involved in those different roles. And with a lot of encouragement from friends as well, just decided to go for the role of editor-in-chief. Was really thankful to be elected in that role. All the executive board roles are elected, and then there are other roles that are assigned based on preferences. And so took on that role, and then had that over my 3L year, and incredibly thankful. Really just had an amazing experience with my fellow executive board members and just all the other 3Ls, and getting to just lead and assist the 2Ls in that way was just really, really fun. It was awesome.
And I think we all agree you did a pretty good job
Yeah.
as well.
Well, thanks.
Definitely.
I'm really glad.
I'm glad I peer pressured you.
I am too.
My journey, I had a bit of an existential crisis immediately preceding application to Law Review, in that I both wanted to do Law Review and wanted to do Moot Court, but I was doing too many other things to do both. So I wound up picking Law Review in part because, it was a chance to write for academic publication, and that's a thing that you may not get to do again if you don't go back into academia or don't find time to do it necessarily. And so I wanted to take advantage of the opportunity. I wound up writing on. The write-on wasn't terrible for me, but that's because I like BSing off the cuff. So it was sort of a fun exercise, and pick a position and then figure out how to argue it later. So that was kind of fun for me. But once I got on, I did traditional track both times because I can't shut up. And so 8 pages was not going to be enough. I would have written 25 pages and then had
Honestly,
to
same.
edit it down to 8 pages. It would have been a nightmare. So did that for 2 times, wrote on very nerdy con law things. And then I last minute, I think I decided to run the night prior to the election for managing editor. And I liked the role in part because it was the nerdiest sounding of all the e-board roles. It was basically you read a bunch of submissions by scholars, and you are sort of the first line of defense and in charge of trying to coordinate the lead articles that the academics and professionals are submitting to the Law Review, and trying to figure out which ones to publish and that sort of stuff. So I like the idea of reading a bunch of academic legal scholarship, and so I decided to do it, ran, got
Killed
elected. It's been a great time, and now Cece gets the stress of reading all those articles.
Yeah, you did an amazing job.
I mean, as for me, coming from, not being American and not coming from the American legal system or anything like that, I didn't really know about Law Review before I came to law school. I didn't really know it was a thing, and so coming here, it seemed to be. I gradually learned over the course of my first year that it was the thing that was something that you could do, And it was a thing that was seen as a positive. And then I learned a bit more about it. I thought, well, that sounds quite interesting, getting to chance to write about all these interesting topics and to do all these different interesting things, and a chance to also have a leadership role here at the College of Law. And so that was really the impetus for me. And even though I found the write-on very difficult because con law topics are not my forte, I got through it and then was able to write about topics that I really cared about and I was really interested in, which is all related to international law. So I was able to do that for my first year. I did a traditional article for the first semester and then a series of blogs all about international law and one of them was about space law, so beyond the international.
International law.
Exactly, yes, interplanetary law. And then in going into my 3L year, I wanted to have that opportunity to work in a leadership position. But one perhaps that was less closely related to the pure academic side of things. And so here we have a role on the executive board, which is the business manager and outreach director role, which involves doing the snacks for the office, as Griff said, very important role, as well as doing things like our merchandise, and then more importantly perhaps, reaching out to and connecting with alumni and with the greater Cincinnati community.
And you ran all of our finances.
And all of our all the finances too. And
it's a big job. Yeah.
Exactly. And this was something I hadn't
You did the
really,
grown-up thing.
And this was something that I hadn't really had the chance to do before. And so this was my opportunity to work in that kind of position and that kind of role, and working with Megan and the rest of the e-board and putting all these things together, pushing together new alumni events or restarting them really after the pandemic, building those connections. I found it really worthwhile, and it was something that I felt I could contribute most to the Law Review and to the law school.
You were so good at it.
Thank you.
So my kind of path was coming out of 1L year and kind of looking at how I wanted to get even more involved in school next year. I genuinely do love writing. It's my favorite part of school. It's my favorite part of my job. So Law Review was kind of the obvious choice for me. I chose the hybrid track because I wanted to have two different experiences of two different types of writing. And now I'm going into my 3L year. I'm Griff's successor. So I'll be doing that, and I'm really excited for final year.
Perfect. Well, thank you all for explaining Law Review to potentially anyone who's listening who might be interested in Law Review or law school or just the law in general. As always, the link to the Law Review's website, their blogs, anything else like that we will have will be below this episode. And also
like and subscribe.
Yes. And also go and check out the articles. Read a blog. Read something that sounds interesting to you. And just show support in that way, I think, is something Law Review would definitely love, is just having their pieces that they've worked hard on being read by someone who appreciates them. So go out and do that. Listen for the other 2 episodes to get more in depth on what those writings sound like, what they are, how they work through them, and then also what the future of Law Review at UC looks like for the upcoming year. And I thank you all for coming, taking time out of your some of you graduated days to come and talk about this. And for those listening, hopefully we'll have more interviews with Law Review about topics and blogs that they're going to be working on throughout.